This guy pleads guilty to arson, then insists the fire was an accident, leading to a tense confrontation with the judge. This video captures the moment a man faces a tough reality check about his choices and the serious consequences of his behavior, both in and out of the courtroom.
Well, I'm concerned about his behavior, but I'm just as concerned about the fact that he denied the offense.
Yes.
So if you didn't do it, then you shouldn't have pled guilty. All right, sir, are you Avon Johnson? And this is 24 DCCR 2044. Mr. Johnson was previously in court, entered a plea of guilty to the offense of arson, intending to damage a habitation or place of worship. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections?
So no corrections, but there is an issue. Ms. Malfino and I have spoken about this. On page 2, at the very top where it says restitution issues, it looks like there's an outstanding bill, if you will, for repairs in the amount of $150,000, but I don't know if that's the actual case. I think that those
And I would agree, Judge, if I may, Lori,
Sure.
that figure came from the fire department, not from the apartment complex.
Okay.
The apartment complex may be under governmental control, and that may have taken care of the issue. With respect to what Marshal Hurdle said in the PSI, I know him very well, actually, and he didn't understand some of the predicament I was in with respect to the complainant that I had let the court know in advance about her mental status and cognitive ability to testify, etc. If you would like me to take a deeper dive into where that restitution is owed, if any, that's obviously way substantial amount to order Mr. Johnson. I am concerned about his behavior.
Well,
awaiting
I'm
sentencing.
concerned about his behavior, but I'm just as concerned about the fact that he denied the
He learned it
offense.
on her right.
yes.
So if you didn't do it, then you shouldn't have pled guilty. And so that's what a jury's for, to come in and decide if you are guilty or not. This says, at least what they put in here, that you said that there was a bottle of lighter fluid on the floor, that she flicked a cigarette and the fire just started, which is different than that's obviously not arson, that's an accident. And so we've got to get past that before we do anything else. So either you did what they charged you with, which is starting it in anger or whatever else was going on, or not. So did you do it? Did you not do it?
I wouldn't say I did it, but I would say that I contributed it to it. We were kind of wrestling, and it just happened.
Again, that sounds like an accident, not arson. Because here's the thing. I mean, a 5-year deferred probation is a great deal. I mean, you don't have, well, I say that. You do have criminal history and a revocation. So I don't know. Anyway, if you violate your probation later and you're back in here on a motion to revoke, it's a first, right? I mean, you're looking at 5 to 99. And if I say, you know what, I think you deserve 25 years in prison, you can't say, well, I didn't really do it back then. I shouldn't have pled guilty. So you're stuck. So either you did it or you didn't do it. You know, when you were here before, you were standing in front, you stood in front of the clerk, you took an oath, you said, you're going to tell the truth. And so telling the truth is either accepting responsibility if you did it, or saying it was an accident. And if it was an accident, it's an accident.
But I played out to it. I played guilty to it, and I accepted the charge for arson. I understood what I was doing.
Okay, all that's great. Did you do all of that because you're guilty of the offense?
Yes, ma'am.
Okay, so I guess what we need to do at that point, then I don't mind. The only problem is I need to have that restitution before sentencing.
Yes, ma'am.
But I don't want him, if he's getting a deferred, he didn't need to be sitting in jail.
An idea might be, if I may, Judge, to order not to exceed that amount. I will confirm, and then we can
Sure.
drop it to.
You've done that before.
Yeah, that's probably the easier way to go ahead and get it sentenced so you can get out. Obviously, I wouldn't expect that it would be anywhere near that, though. I mean, that would,
If you understand my position of
Sure,
what I'm saying
absolutely.
about where
I
it
do.
was.
Yeah, and then if you, if there's an issue when the restitution amount, if any, comes out, and we need to have some type of hearing on that, then we can still do that even though he's sentenced if I do a not to exceed amount.
Yes, ma'am.
So do you understand, Mr. Johnson? What I'm going to do is go ahead and give you the probation today. I'm going to order restitution not to exceed $150,000. No one expects, I don't think, for it to be that, or maybe, who knows what, maybe not anything, maybe much lower than that, depending on insurance and whatever else. If there's an issue with that, we can handle it later, but that way we can get you sentenced today and you can go ahead and be released. Do you understand? Now, if there is restitution, and you will be required to pay it on that probation, so it's really important that if there is any ordered, that you start making payments on whatever it is, every single month, even if it's just a little bit, to show me that you're making those payments, okay? So what I'm gonna do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney. Defer all proceedings for a period of 5 years. There will not be a fine in your case. There will be restitution ordered in the amount of not to exceed $150,000. Now, I have a note here that if I accept this agreement, there might be something else I do because of your jail incident reports. You know, I mean, you were just in a fight in July out there. June, talking disrespectfully to, I'm not real sure what's going on in the jail to make any of you that are sitting in jail thinking that the correctional officers are going to somehow have anything to do with you when you get out of jail. I mean, really, you think that's where you're going to meet your next girlfriend?
No,
Then you shouldn't be talking to them like that, right? I mean, you threatened one male officer that you were gonna beat his ass.
could I say something about that?
I don't know, you probably shouldn't. How old are you?
I'm 32, maybe something.
You're too old to be acting like this. This is the kind of stuff I'm getting on the little young punks out there. You know who I'm talking about, all of them that are out there acting like heathens. That shouldn't be you. You're not doing near as much as all them, but I shouldn't be having this on somebody that's in their 30s. I mean, you've already been on probation and know what it takes to be on probation and didn't do it. So I hope that by going forward today, you understand, just like I said, if you follow all of the rules of this probation, great opportunity, right? You don't have this conviction on your record, you get out, you live it like the rest of us. If you violate any condition of probation, you're brought back into court, you become a convicted felon on this case, and I have the whole range of punishment, which is 5 to 99 or life. And I'm gonna look back at that time and see that I gave you an opportunity on probation when you just revoked a probation 2 years ago. And so it's probably not gonna be some little mountain prison and you just get to go on your way. It's gonna be, you need to start learning from your mistakes kind of thing, right? Make sense? All right. So I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. Probation will give you some information today before you leave. Make sure as soon as you get out, first thing you do is go to probation, okay? All right, good luck.
Thank you.
Thank you, Judge.
Thank you.